Hello, welcome to EPG Pathshala. Myself Mukul Razada, Assistant Professor, National Law University, Delhi. Today I am going to speak upon the module named International Concerns for the Victim of Crime. The prerequisites of this module are: for the proper understanding of the initiative taken towards victim justice, it is required to understand what role does the victim of crime has under present criminal justice system and how his needs and rights are being addressed. The objectives of this module are to impart knowledge about the recognition of victims' needs and rights as a human being under the criminal justice system, to impart knowledge regarding the ideals or aspirational goals set out by the UN Declaration of Basic Principles of Justice for Victims of Crimes and Abuse of Power 1985, to discuss the concept of victimization and various identified rights for victim of crime under the UN Declaration of Basic Principle of Justice for Victim of Crime and Abuse of Power 1985, to get an insight into practice prevalence under other criminal justice system through the study of guide, to present a comprehensive scheme of the provisions of handbook to understand what steps can be undertaken to make the criminal justice system much more victim sensitive. Now we will proceed to the conceptual part of this module so as to know what this module talks about. To address the pathetic condition of crime victims who first faces victimization at the hands of the offender and then faces the secondary victimization in the form of sensitive and unsympathetic treatment by the agencies of criminal justice system, certain initiatives were taken by the United Nations. These initiatives resulted in the form of Declaration of Basic Principle of Justice for Victim of Crime and Abuse of Power 1985 that sets out the goal to be achieved for the justice of victim of the crime. Guide for the Policymaker 1999 that provided a glimpse of measures being practiced in different criminal justice systems and what all states should follow. Handbook Justice for Victim 1999 that gives a set of examples to be followed by the agencies of criminal justice system to make the criminal justice system much more victim sensitive. By highlighting these instruments, this module tries to provide a clear picture of the United Nations understanding on the victim issue. Studies conducted by Benjamin Mendelsohn and Hon van Henting in 1940 brought attention towards the suffering of the victims incurred either due to the primary victimization or the offender or due to the secondary victimization from the agencies of criminal justice system. As a result of renewed interest in victim issues, various victim movements raised issues such as shelter for battered women, compensation and conciliation issues. For other initiatives in the direction of advancing victims' concerns can be mentioned, for example, New Zealand adopted first state compensation scheme for victims in 1963. United Kingdom established shelter for domestic violence victims and established crisis center for sexual assault victims in 1970. World Society of Victimology was established in 1979. European Convention on the Compensation of Victims of Violent Crime was adopted in 1983. Recommendations on the position of the victim within the framework of criminal law and procedure 1985, and Recommendation on Assistance to Victim and the Prevention of Victimization 1987, and finally adoption of the Declaration of Basic Principle of Justice for Victim of Crime and Abuse of Power by the United Nations in 1985. Now we talk about the Declaration of 1985. United Nations General Assembly took cognizance of the fact that throughout the world there is a lack of initiative taken towards the victim of crime and the crime abuse of power. General Assembly also recognized the fact that the suffering of the victims are not limited with the immediate or direct sufferer of a crime. Rather, it extends to vicarious victims such as family members, immediate victim witnesses in the case, and persons who come to help the victim in a case, and also suffer secondary victimization. that results due to the criminal justice process. The declaration was adopted by the General Assembly of the United Nations on 29 November 1985 at its 96th plenary meeting with the objective of adopting national international measures that are sufficient enough to give due respect to the rights of victims of crime, promoting states to take effective steps in this direction but without being prejudicial to the rights of the suspect or offender, providing an assistance to the government and international community so they can ensure justice and provide assistance for the crime victim. This declaration calls upon member states to give effect to the provisions of this declaration by making specific policies that may reduce victimization and may provide assistance to the victim, inclusive of such policies, health policy including both physical and mental health policy, educational and economic policy, and any other policies for preventing victimization. Member states should review their law time to time that whether these laws, both in theory and in practice, are responsive enough or not for addressing victims' concerns, and to make efforts to enact and enforce new legislation to provide protection to internationally recognized norms of human rights. Member states are supposed to provide an effective machinery of the criminal justice system to make it more effective to detect, prosecute, and sentence those found guilty of the crime. Member states should endeavor to promote observance of the International Code of Conduct and international ethical norms by public servants that includes law enforcement officials, correctional, medical, social service, etc. in their dealing with victims of crime. In cases where there is a need to detect the offender or to extradite him or to seize his assets for the purpose of victim restitution, all member states should cooperate. Recommendations were made by General Assembly at international and regional levels. Such training programs be conducted to ensure observance of the United Nations standards and norms. Steps should be undertaken for the collaborative and action research to find out the ways of minimizing victimization, providing aids to victims, and exchange of information on effective means. Requesting governments should be provided with the direct aid for the purpose of reducing victimization and reducing victim sufferings. Requests were also made by the General Assembly to the Secretary General. The Secretary General should invite member states to report the status to the General Assembly about how far the declaration is being implemented and what all steps they have taken for the implementation of this declaration. That Secretary General should use all available measures within the United Nations system in a case a member state needs assistance in improving its ways and means to protecting victims. Secretary General should take measures that are helpful in promoting the objectives of this declaration, such as widest dissemination of this declaration. Declaration of 1985 defines victim as that victim means persons who individually or collectively have suffered harm including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omission that are in violation of criminal laws operative within member states, including those laws prescribing criminal abuse of power. Following inferences can be drawn from the above definition that the victim of crime include victim of violation of national criminal laws as well as victim of criminal abuse of power. Victim status is not dependent upon the status of the perpetrator of the crime, that is, whether he is identified, apprehended, prosecuted, or convicted. Victim's status does not get adversely affected merely by the presence of a relationship between the victim and the perpetrator of a crime. The term victim is inclusive of both direct sufferer of a crime as well as indirect sufferer of a crime. This definition leaves no scope for any type of discrimination while deciding the status of victim. It prohibits all kinds of discrimination. Victimization is also defined in the wide sense, covering all type of possible effects and harm of crime that include physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights. This effect may be result of an act or an omission. Victims' right, reflecting the collective will of international community, the declaration has recognized four main rights of the victim, that is, right to access to justice and fair treatment, right to restitution, right to compensation, and right to assistance. For effective realization of the basic right to access to justice and fair treatment, the declaration has further recognized various rights such as dignified treatment, access to justice, mechanism for prompt redress through a fair procedure, information and notification, to present his views and concern, minimum inconvenience, safety and security, privacy and speedy disposal of the case, etc. Guides for Policymaker 1992. This is another initiative taken by the UN for the victims' rights. This guide has been developed to provide assistance to member states for improving the position of victims into their national criminal justice system. The government should develop such support and programs that help in minimizing the chances of victimization in the society. This guide reflects upon the measures already taken and measures that are needed to be taken in making the criminal justice system much more fair and effective for the victim of crime. It follows the structure provided by the declaration and for effective implementation of the declaration. It gives some useful and effective suggestions. As far as initiative to be taken by the member states are concerned, it provides that there should be a comprehensive strategy-based policies to implement the declaration. First step in the development of such policy is to establish a high-level committee or a working group within a wide representation from all sectors by carrying out specific studies in victims' needs and other related aspects to assess the obstacles to the victim access to justice, and if there is a gap between need and services, making suggestion for better treatment of victim of crime. The guide observes the state should come forward to develop and ratify international and regional conventions and make efforts to incorporate victims-related provisions into their national legislations. For implementation of crime prevention policies, states should take measures to provide services and information pertaining to crime prevention and human rights of victims. To promote training programs for creating sensitivity towards victims' needs and concerns. For promotion of public participation, states can establish crime prevention councils to mobilize the community in participating in the crime prevention. For timely review of laws, state can establish permanent review boards within the legislative and administrative bodies, and opinion of independent experts can be taken into consideration. For effective machinery for implementation of laws, states can take measures like to establish an institution of ombudsman to conduct an impartial investigation into cases of abuse, to sign bilateral or multilateral convention to make extradition possible, to protect victim witness from intimidation or retaliation. To bring the ethical norms in practice, states can take measures like imparting training to public servants for observance of international human rights norms, to issue guidelines for the agencies of criminal justice system regarding treatment of crime victims, to establish means for assuring adherence to such code of conduct. Regarding the request made to the Secretary General, it was noted in the guide that the Secretary General should take measures such as encouraging the states to provide the periodical report on the implementation of the declaration and measures taken by the member state, to make efforts for developing a United Nations clearinghouse on information relating to victim issues, to make efforts to develop a mechanism that can integrate the isolated efforts of different nations to get a synergetic effect. For widest dissemination of the declaration, it should be included in all human rights publications by developing a handbook for practitioners, by developing a database. Regarding initiative taken by some jurisdiction for 4 basic rights of the victim of crime recognized by declaration, it has been observed under the guide that some jurisdictions have developed guidelines for proper conduct and some have introduced Victims' Bill of Rights. Some jurisdictions are not limiting redress with only providing of financial reparation, but include formal acknowledgements through the criminal justice system or informal apology by the offender for the harm done to the victim. Regarding victims' right to procedural fairness, it has been observed that some jurisdictions give victims a choice of civil claim along with the criminal proceedings, that is, partie civile in France-based system. In some jurisdictions, neglect by the agencies of criminal justice system towards victims' rights may lead to administrative sanctions, for example, in Mexico. Regarding victims' right to get a responsive system of judicial and administrative process, guides provide that some jurisdictions are trying to keep victim informed by publication of books and brochures, designating a specific agency for this purpose, and personal discussions with the prosecutors. Some jurisdictions use victim impact statement to assess the seriousness of the offenses, for example, in Australia, New Zealand, and United States. Some jurisdictions considers victim as a subsidiary prosecutor like in Australia, while other considers victim's view on sentence and on release like in United States. Regarding victim assistance throughout the legal processes, it observed that some jurisdictions have provisions of cost-free legal trial proceedings for victims in need, for example in Finland and in India. Some are establishing victim support programs either through law enforcement agencies or through social workers or through the creation of a post of support person which is paid by the state. Regarding minimizing of the victim's inconvenience, various jurisdictions have developed guidelines that balance the interest of victim with the offender by applying measures such as prompt return of property, immediate reimbursement of the expenses incurred on the criminal proceedings, specific mention of the time when witness may be required to give testimony, and developments of the victim-sensitive code of ethics. Some jurisdictions have adopted various methods for timely and fair restitution to victims, such as making it as a mitigating factor in sentencing, imposition of a higher fine in case of non-payment of restitution, seizing the assets of offender, and creative restitution. Some jurisdictions are imposing sanctions that have close relationship with restitution to the victims, such as financial community restitution, community service, etc. Regarding the establishment of the funds for victim compensation, some jurisdictions have schemes that can be funded through fines, civil surcharges, assets seized from the offender, etc. Contribution to these schemes are promoted by the providing financial exemptions to the donor. Guide mentions also that various jurisdictions are adopting establishment of victim services programs and review their services, development of guidelines on how to deal with victims of crime, financial assistance to the victim. It has been observed in the guide that such victim programs needs a correct assessment of victims' needs, defining the goals to be achieved that can be ascertained by conducting victimization survey. Under some jurisdictions, victim assistance centers provide paralegal services also. Regarding informing the victims, various jurisdictions are using methods such as distribution of brochures and booklets, screening of police reports by some trained crisis counselor to find out the victims in need, and referral to victim services programs by law enforcement personnel. For police training, skills in on-site crisis intervention, securing emergency medical assistance, informing victims about their rights, and making of referrals to services are being undertaken by several jurisdictions, and some other jurisdictions have developed protocols for various professional, and some are using peer review systems to make the police sensitive towards victim-centric issues. As a companion to this guide, there is a handbook that prescribes various forms of assistance that can be given to the victim of crime and identifies roles and responsibilities of various agencies of criminal justice systems in the effective implementation of rights of victim of crime. Handbook of Justice for Victim 1999. This handbook on justice for victim was developed in response to the resolution Economic and Social Council Resolution 1996/14 of United Nations Commissions on Crime Prevention and Criminal Justice to develop manual on the use and application of the declaration. This handbooks work as a tool for implementation of victim services program and for developing victim-sensitive policies, procedures, and protocols for criminal justice agencies. This handbook gives only a set of examples and is not prescriptive in nature. This mainly deals with the impact of victimization, victim assistance programs, and role and responsibility of frontline professionals and others who deal with the victim. Taking first the victim of victimization. Three aspects of victimizations have been dealt with in this handbook: physical and financial impact of victimization. These may include a number of symptoms that occur either at the time of commission of offense or after the criminal offense has been committed. Financial impact may include medical expenses, loss of property, expenses on security measures, loss of wages, and expenses incurred in the criminal justice process. Psychological injuries and social costs have been dealt with by handbook by stating that an individual may respond directly to a crime, but common reactions of victim of crime passes through 4 stages generally. They are initial reaction, a period of disorganization or psychological effects, followed by a period of reconstruction, and finally the period of acceptance. It is not easy for all victims to go through these stages easily. They may swing between these stages for a quite long time. Secondary victimization from the criminal justice system and society has been dealt by the handbook in the sense that victim faces this secondary victimization from the criminal justice system when the agencies of the criminal justice system treat them in an insensitive and unsympathetic manner while subverting victims' interest by not accepting victim versions of event, intrusive or inappropriate questioning, media reporting, intrusion into victim privacy, etc. Victim assistance programs. The handbook talks about that there is an understanding that victims need assistance for overcoming the trauma of their victimization. Victim assistance programs are designed keeping in mind victims' need for coping with victimization and ease in doing through the various stages of criminal justice process. Handbook prescribes different types of services to be provided by any victim assistance program. For crisis intervention counseling, emergency referrals, safety and security concerns, informing victims about their rights. For counseling, supportive individual or group counseling, direct assistance for protective shelter, information to prevent further victimization, substance abuse, and about the availability of the social and health services. For advocacy, to facilitate easy access to criminal justice system, drafting application, intervention to ensure continuity of essential services, assistance with protection orders, support during investigation, emotional support to victim by accompanying him at the time of identification of or crime scene visits, direct support for shelter and protection, information as to the progress of the investigation, procedural aspects, victim's rights status of the offender, medical assistance, protection of the evidence, and prevention of further victimization. Support during prosecution and trial. For this, support at the time of interviews, testifying process and trial, direct support with minimizing victim's appearance, transport reimbursement, separate waiting areas, and restitution. Information as to victims' role and rights and role and responsibilities of criminal justice personnel and case developments. For support after case disposition, supportive counseling during appellate process, direct assistance in relation to enforcement of restitution orders and proceedings in relation to parole, probation, and pardon. Also, information as to victims' rights and offenders' status. Services also includes training for professionals and training for all who comes in contact with the victim. For prevention, services include prevention of future victimization. Public awareness programs include public awareness programs to create victim sensitivity. Establishing standards of good practice includes written standards of good practice to ensure high level of services. The role and responsibility of frontline professionals and others to victim. This handbook suggests the methods to be taken by the frontline professionals as they play an important role in ensuring justice to the victim. Dignified treatment from these professionals help the victim in easy recovery from their trauma, whereas unsympathetic and insensitive treatment results into secondary victimization of victims. First, we will take police and victim assistance. Police is the frontline agency of criminal justice system and should perform its duty in a sensitive and sympathetic manner by condemning the incidents of victimization and assuring victims about his safety, provide psychological first aid to the victims. Protocols should be developed for first contact persons, patrol officers, investigators, and supervisors. Police training should include, as part of their curriculum, the understanding of trauma of victimization, empathizing with victim to easily establish a rapport with the victim, providing victim with on-site crisis intervention, ability of the officer to refer victim to the needed support group and providing information pertaining to progress in the investigation, ways to protect valuable evidence from being destroyed, and dealing with special categories of the victims. Prosecutors and victim assistance. This includes the fact that the victim has a valid interest in prosecution of the case. Many jurisdictions provide prosecutor-based victim assistance involving notification of the case status and of delays, protection from intimidation, assistance in attending and participating in court proceedings, referrals to victim assistance and victims compensation programs. Prosecutors should be imparted with in-service training on victim-centric issues such as responsibility of providing information, translation and notifications, helping victims to understand the basic processes of criminal justice system, coordinating victim impact statements in court proceedings if applicable in that justice system, providing separate child-friendly, safe and secure waiting areas for the victim of the crime. The role of judiciary in the justice for the victim. This handbook has made recommendations for the judiciary to take into consideration the legitimate interest of victims at all procedural stages. Judges should be given training on victim-centric issues to ensure that victims have been provided relevant information regarding various issues such as their rights, witness fees, compensation funds, and information regarding the status of their cases. They should provide support for separate waiting areas, services of interpreter to minimize inconvenience from unnecessary visit to court, child care services, measures to prevent any form of threatening or victim intimidation, expediting the trials, use of specially designed courts room or videotape deposition for special categories of victims should be permitted. Taking into consideration the national laws, victims should be allowed to participate and give their input at all stages of criminal justice processes. For prison and alternative sanctions, victim suffers a fear of retaliation by the offender for bringing him to the criminal justice system and has a legitimate interest in getting the notification concerning offender's release. Probation officers should take into consideration victim's opinion regarding community service. Sanctions for probationers should supervise mediation where victim wishes to participate with the offender. Correctional authorities, that is the prison authorities, they should place victim-related important information in offender's file and protect this information by making it non-available to offenders or to his counsel. On a request being made, the authorities should provide information to the victim regarding offender's potential release date or his escape or his death. National Organization for Victim Assistance, that is NOVA USA. It was founded in 1975 and NOVA is a private non-profit charitable organization. NOVA's mission is to fight for dignity and compassion for victims of crime. Formation of NOVA in 1975 helped in consolidating the objectives of various victims movements going on in USA. NOVA followed from First National Conference on Victim Assistance in 1973. NOVA promoted networking and conducted national conference to impart training for persons associated with victims. During 1980s, taking into consideration growing demands that victims should be given a legitimate access to the justice system, NOVA founded a new platform for victims' rights. As a result of this initiative, a National Victims' Rights Week was endorsed and implemented in 1981 by President Ronald Reagan. Office of Victim of Crime in association with NOVA developed the Model Victim Assistance Program, brief in 1986 to 1988, that emphasized upon 8 types of services that should be provided under any victim service program. NOVA initiated practical model for community crisis intervention that led to the functioning of first crisis response team in 1986. So to conclude this module highlights the approaches of the United Nations toward the victim's right. It in clear terms depicts the picture of the victim to be considered as a human being with certain inherent needs and rights. United Nations instruments emphasize that states should recognize victim status into their national criminal justice system, and victims should be given due respect and recognition throughout the criminal justice process. Victims' needs should be properly dealt with, and his rights should clearly be recognized under the national criminal justice system. States should take efforts to establish such programs that provide the needed assistance to the victim of crime. States should take further measures to sensitize the functionaries of criminal justice system and all other concerns toward the victim's issues. Thanks for watching this module. Hope this was an enlightening experience.